Let me tell you what just happened to Atiku Abubakar in a Nigerian court on Monday, and then let me tell you what it means for you and for the 2027 election. The Court of Appeal in Abuja, in a split decision of 2 judges to 1, has upheld a federal high court order barring INEC from recognizing or participating in any state congresses organized by the David Mark-led leadership of the African Democratic Congress. The court also ordered the ADC to pay costs of 10 million naira. Now, here is why that matters so much. Atiku Abubakar got his ADC presidential ticket through a national congress organized by that same David Mark-led leadership. The running mate he announced, former Rivers State Governor Rotimi was also confirmed through that same process. The court has now ruled that the congresses and national convention conducted by the Mark-led leadership were null and void because they were conducted in violation of a subsisting court order. Atiku is saying, do not panic. He is saying the ruling only affects party congresses and not the primary elections through which candidates were nominated. He is heading to the Supreme Court. He says the road to 2027 remains open. But here's the question that his statement does not answer. If the party structure that organized his ticket was declared invalid by 2 separate courts, what exactly is the legal foundation of that ticket? And with the Supreme Court case potentially running past the 2027 election date, is Atiku actually safe on the ballot? Stay with me, because this is the most important legal development in the 2027 election so far, and it is moving fast. The full court story, from April to yesterday. Let me take you through exactly what happened in this case from the beginning. Because to understand the July 13 ruling, you need to understand where it came from. The African Democratic Congress has been in a leadership crisis since early 2026, when Atiku, Aregbesola, David Mark, and others entered the ADC as a coalition platform for 2027. They came in through a caretaker committee arrangement. That caretaker committee, led by former Senate President David Mark, was given authority to manage the party's affairs and organize the internal elections needed to prepare for 2027. But here is the problem. 7 aggrieved ADC members went to court. They are Don Norman Obinna, Johnny Tovi Derek, Oba Ehigiato, Olonya Yinka, Charles Omideji, Samuel Gang, and Obianyo Patrick. They filed suit number FHC/ABJ/CS/581/2026. They argued one clear point. Under the ADC Constitution and the 1999 Nigerian Constitution, only duly elected state party organs, meaning state executive committees that were already in place, have the authority to organize state congresses. The David Mark-led caretaker committee, they argued, had no constitutional power to appoint committees to conduct those congresses. On April 14, 2026, a federal high court issued an interim order telling the Mark-led leadership to stop. On April 29th, Justice Joyce Abdul Malik delivered her full judgment. She agreed with the 7 plaintiffs. She held that the 4-year tenure of the ADC's existing state executive committees remained valid and that the caretaker leadership had no power to override them. She barred INEC from recognizing any congresses the Mark-led group conducted. The Mark-led ADC appealed. Their case went to the Court of Appeal marked CA/ABJ/CV/608/2026. On July 13th, 3 appeal court judges heard the arguments. Justice Okon Abang led the lead judgment, supported by Justice Donatus Okorowo. The presiding justice, Justice Abba Muhammad, dissented. 2-1. The Federal High Court judgment was affirmed. The appeal was dismissed. 10 million naira in costs was awarded against the ADC. Justice Abang went further than simply upholding the lower court. He said the court's intervention was necessary to ensure anarchy and the survival of democracy in Nigeria. Those are strong words from an appellate court judge. They signal that the court viewed the MARC-led ADC's conduct as something more serious than a simple internal party dispute. The critical legal finding that everyone needs to understand is this. The court held that the congresses and national convention conducted by the MARC-led leadership were null and void because they were conducted in defiance of an existing court order. That April 14 interim order told them to stop. They proceeded anyway. And now a second court has said that because they proceeded in defiance of a court order, everything they did is legally void. That includes the National Convention, where Atiku was confirmed as the ADC presidential candidate. That includes the Congress processes that formed the party infrastructure for the 2027 election. All of it, the court has found, was done in defiance of a court order that was already in place. The ADC is now heading to the Supreme Court. Their National Publicity Secretary, Malam Bolaji Abdullahi, has said the party will challenge the verdict. Atiku himself has instructed his legal team to file at the Supreme Court, and they have said clearly that they believe the Supreme Court will provide a definitive interpretation in their favor. Does this ruling actually affect Atiku's presidential ticket? Now let us address the most important question directly. Atiku is saying the ruling does not affect his presidential ticket. The ADC is saying the ruling only affects party congresses and not party primaries. Are they right? The legal distinction they are making is real, and it deserves to be taken seriously. In Nigerian electoral law, party congresses and party primaries are indeed different processes governed by different legal provisions. A Congress elects party executives at ward, local government, and state levels. A primary election nominates candidates for public office. The court order that was violated and the court's ruling specifically concerned the congresses for electing party executives, not the primary elections through which Atiku were nominated. On that narrow legal point, Atiku's lawyers have an argument. The court did not say the ADC primary that produced Atiku was void. It said the congresses that reorganized the party structure were void because they were conducted in defiance of an existing order. The legal connection everyone is missing is here. The problem with Atiku's argument that most Nigerian media commentators are not explaining clearly enough. A party primary derives its validity from the party structure that organized it. If the party structure that organized Atiku's primary was itself built on congresses that have been declared void and null, the question of whether the primary that emerged from that structure is also legally vulnerable is a question that the Supreme Court will now have to answer. The dissenting judge, Justice Abba Mohammed, said the dispute bordered on internal party affairs and was not justiciable. If the Supreme Court agrees with the dissenting view and then extends it to the primary elections, Atiku's entire candidacy is in legal jeopardy. That is the risk he is living with right now, and that risk does not go away until the Supreme Court rules definitively. There is also a timing problem. The 2027 presidential election is on January 16. The Supreme Court in Nigeria, while capable of moving quickly on electoral matters, is dealing with a docket that includes multiple election-related cases for multiple parties simultaneously. A definitive Supreme Court ruling on the ADC leadership question before January 16 is possible but not guaranteed. If the case is still pending when the election arrives, INEC will have to make an operational decision about which version of the ADC it recognizes for ballot purposes. And that decision, made by INEC Chairman Professor Joash Amupitan, is itself already contested. Atiku has alleged that Amupitan was appointed specifically to destroy opposition parties. The Electoral Commission has been accused of incompetence by the NNPP. Multiple parties have complained about INEC's handling of their internal disputes. The Electoral Commission is not a neutral arbiter in this environment, and the decision it makes about which ADC faction it recognizes will be one of the most consequential electoral decisions before January 2027. The running mate, the forged documents, and the ADC's deepest problem. Now, let us talk about the dimension of this story that most people are not paying attention to. The running mate and the forgery allegation. Atiku announced former Rivers State Governor Rotimi as his ADC vice presidential candidate. That announcement was significant for multiple reasons. Amaichi brings southern credentials to a northern-led ticket. He is a former APC stalwart with deep knowledge of federal government operations, and his inclusion was designed to signal that the ADC was a serious cross-regional coalition rather than a northern political vehicle with a southern face. But Vanguard reported that Atiku is now alleging that someone submitted a forged INEC document as a fake nomination upload for a different candidate, attempting to displace either Atiku or Amaichi from the INEC portal. Atiku said in his statement that INEC denied granting Nafiu Gombe access to its nomination portal, but that the ADC has evidence that a fake nomination was attempted. This means someone, inside or connected to the rival ADC faction, allegedly attempted to fraudulently alter the official INEC candidate nomination portal for a presidential election. Here is what the forgery allegation reveals that goes beyond the ADC's immediate legal crisis. If someone has actually attempted to fraudulently alter INEC's candidate nomination portal for a presidential election, that is a criminal matter involving the integrity of Nigeria's entire electoral infrastructure. The INEC portal is the official record of who is running for president of Nigeria. An attempt to fraudulently alter it should trigger an immediate investigation by the EFCC and the police, independent of any party dispute. If the ADC has evidence of this and has submitted it to INEC, and if INEC does not refer the matter for prosecution, the question of INEC's seriousness as an independent electoral commission becomes even more acute than it already is. This is not just a Atiku problem, it is a Nigerian democracy problem. The broader strategic picture for Atiku is now this. He is fighting a two-front legal war. On the first front, the appeal court ruling on the congresses that he is taking to the Supreme Court. On the second front, the alleged forgery on the INEC portal that he says his legal team is addressing. Both fronts are active simultaneously. Both require legal resources, strategic attention, and time. And both are consuming the energy and attention of a presidential campaign that should by now be focused on voter mobilization, policy development, and constituency outreach. A presidential candidate who spends the 6 months before an election in court is a presidential candidate who is not building the ground-level political machine needed to win. Every day Atiku spends fighting for his party's legal existence is a day he is not spending persuading undecided voters in Kaduna, Borno, Kano, and the Middle Belt that he is the better choice for Nigeria. Drop a comment right now. Do you think Atiku can survive this legal crisis and still win in 2027? Or has the opposition already handed Tinubu the election? Tell me your honest view before we get to the section that connects all of this to the bigger picture. The ADC, the NDC, and the opposition that cannot stop collapsing. Let us step back from the specific legal question and look at the bigger picture. Because the ADC court ruling on July 13 is not an isolated event. It is the latest episode in a pattern that has now played out across every major opposition platform in the 2027 cycle. The Labour Party imploded after 2023 with Obi's departure and a leadership crisis that is still unresolved. The PDP has been effectively neutralized as a national opposition force with Wike's alignment with Tinubu. The ADC, which was supposed to be the unity platform, is now fighting a 2-1 Court of Appeal ruling with its candidacy processes in legal question. And the NDC, Peter Obi's current vehicle, had its own registration suspended by a federal high court on June 26 and is fighting its own appeal. The two leading opposition presidential candidates in the 2027 election, Atiku on the ADC and Obi on the NDC, are both simultaneously fighting court-ordered threats to the legal existence of their respective party platforms with 7 months until the election. The APC's response to the ADC ruling was immediate and precisely aimed. The APC criticized opposition parties for failing to meet the INEC deadline for candidate submission, citing their unpreparedness for the 2027 elections. That message is politically effective because it is partly accurate. The ADC and NDC legal crises are not only about external persecution, they are also about the organizational failures and internal conflicts that have characterized every opposition coalition in this cycle. Governor Seyi Makinde of Oyo State, one of the most credible opposition voices in Nigerian politics, said publicly that Nigeria's political climate is toxic for opposition ahead of the 2027 election. He is right, and the toxicity is both externally applied and internally generated. Those two sources of toxicity feed each other in ways that are very difficult to separate cleanly. The question that nobody wants to answer. Here is the question that the entire 2027 opposition narrative has avoided. Why is it that the APC, with all its governance failures, its economic record, its Gbajamila scandal, its internal tensions between Tinubu and various governors, has not faced a single successful legal challenge to its party structure heading into 2027, while the ADC fights a 2-1 Court of Appeal ruling and the NDC fights a registration reversal? The APC held its presidential primary in May. Tinubu won with 10.99 million votes. The party confirmed Rotimi as running mate this week, and its legal status is unchallenged. That asymmetry between an incumbent party that operates its internal processes without successful legal disruption and opposition parties that face sustained legal challenges at every critical juncture is either evidence of superior APC organization or evidence of something more structural about how Nigerian courts, INEC, and legal resources operate in the shadow of incumbency. Both explanations deserve serious examination. The ADC, the NDC, and the opposition that cannot stop collapsing. Let us step back from this specific legal question and look at the bigger picture, because the ADC court ruling on July 13 is not an isolated event. It is the latest episode in a pattern that has now played out across every major opposition platform in the 2027 cycle. The Labour Party imploded after 2023 with Obi's departure and a leadership crisis that is still unresolved. The PDP has been effectively neutralized as a national opposition force by Wike's alignment with Tinubu. The ADC, which was supposed to be the unity platform, is now fighting a 2-1 Court of Appeal ruling with its candidacy processes in legal question. And the NDC, Peter Obi's current vehicle, had its own registration suspended by a federal high court on June 26 and is fighting its own appeal. The two leading opposition presidential candidates in the 2027 election, Atiku on the ADC and Obi on the NDC, are both simultaneously fighting court-ordered threats to the legal existence of their respective party platforms with 7 months until the election. The APC's response to the ADC ruling was immediate and precisely aimed. The APC criticized opposition parties for failing to meet the INEC deadline for candidate submission, citing their unpreparedness for the 2027 elections. That message is politically effective because it is partly accurate. The ADC and NDC legal crises are not only about external persecution, they are also about the organizational failures and internal conflicts that have characterized every opposition coalition in this cycle. Governor Seyi Makinde of Oyo State, one of the most credible opposition voices in Nigerian politics, said publicly that Nigeria's political climate is toxic for opposition ahead of 2027. He is right, and the toxicity is both externally applied and internally generated. Those two sources of toxicity feed each other in ways that are very difficult to separate cleanly. Here is the question that the entire 2027 opposition narrative has avoided. Why is it that the APC, with all its governance failures, its economic record, its Gbajamiela scandal, its internal tensions between Tinubu and various governors, has not faced a single successful legal challenge to its party structure heading into 2027? While the ADC fights a 2-to-1 appeal court ruling and the NDC fights a registration reversal. The APC held its presidential primary in May. Tinubu won with 10.99 million votes. The party confirmed Shettima as running mate this week, and its legal status is unchallenged. That asymmetry between an incumbent party that operates its internal processes without successful legal disruption and opposition parties that face sustained legal challenges at every critical juncture, either evidence of superior APC organization or evidence of something more structural about how Nigerian courts, INEC, and legal resources operate in the shadow of incumbency. Both explanations deserve serious examination. 5 signals that will tell you where this goes. Here's exactly what to watch in the next 30 days as this story develops. The first signal is whether the Supreme Court grants a stay of execution on the appeal court ruling. Without that stay, the ruling stands and INEC operates under it. With that stay, the ADC's legal position is temporarily stabilized while the appeal proceeds. Watch for a Supreme Court ruling on the stay application within the next 2 weeks. The second signal is how INEC responds to the ruling. The Commission has already said it recognizes only the David Mark-led ADC leadership for the purpose of candidate submissions, but the court has now ruled against that leadership's congresses. Watch whether INEC issues a new statement about which party faction it recognizes and how that affects the candidate portal. INEC's response will be the most operationally significant development after the Supreme Court stay application. The third signal is whether the original ADC state executive committees, the ones the court said had valid 4-year tenures, attempt to convene their own alternative national convention. If they do, Nigeria will have 2 competing ADC national conventions claiming legitimacy, with a Supreme Court case pending and an election 7 months away. That scenario would be constitutionally unprecedented. The fourth signal is Rotimi Amaechi's public response. Amaechi has been unusually quiet since the ruling. As vice presidential candidate whose own nomination flows from the same contested Congress process, his position is directly affected. Whether he doubles down on the ADC or quietly begins exploring alternatives will tell you something important about how seriously the insiders view the legal risk. The fifth signal is whether Peter Obi and the NNDC make any move toward the ADC in the wake of this ruling. A united Obi-Atiku front, with both campaigns acknowledging that their separate legal crises are weakening both platforms, would be the most rational political response to the current situation. Whether rationality prevails over personal ambition is the defining question of the 2027 opposition story. Here is where we are. A court of appeal has ruled 2-to-1 against ADC leadership structure that produced Atiku's presidential ticket. The court found that the McAfee's-led leadership conducted its congresses in defiance of an existing court order and declared those congresses null and void. Atiku says the ruling does not affect his candidacy. Legal experts say the Supreme Court will have to decide that question definitively. Meanwhile, the NNPC is fighting its own registration battle. The PDP is neutralized by Wike's alignment with Tinubu. The Labour Party is still in internal crisis, and the APC is operating with a confirmed presidential candidate, a confirmed running mate, and no successful legal challenge to its party structure. 7 months before January 16, 2027, the Nigerian opposition is spending its energy in courtrooms rather than in constituencies. Its candidates are defending their right to exist on the ballot rather than explaining why they deserve to win the election, and the clock is running. Atiku says those celebrating today should celebrate with caution. He may be right about that. But those mourning today should also resist despair. The Supreme Court has not ruled, the election has not happened, and Nigerian politics has produced more surprises in shorter time frames than 7 months. Watch the Supreme Court, watch INEC, and watch whether this opposition can stop fighting itself long enough to fight Tinubu. If this analysis gave you clarity on what the ADC court ruling really means for 2027, share it with one Nigerian who needs to understand it. Like this video, subscribe to Post Nigeria HQ, and tell me in the comments, do you think Atiku's ticket is safe, or is the 2027 opposition already broken beyond repair? I will see you in the next one.